I go.
Can you hear him?
And then at the end of the longer form explanation, then I'll open it up to live Q&A. So first, a summary of what has happened. The Virginia General Assembly, as you all know, in 2025 passed for the first time a proposed constitutional amendment, a state constitutional amendment. All constitutional issues here are related to Virginia's state constitution. And they did that in 2025 on Halloween. On Halloween, the Democrat-controlled Virginia General Assembly passed its gerrymandering amendment for the first time. Virginia's state constitution has a requirement in Article 12, Section 1, that there be an intervening election between the first passage of a proposed amendment and the second passage of a proposed amendment. And in Virginia, we have our state elections in odd years. You will all recall that now Governor Spanberger was elected last November, as was the entire House of Delegates of Virginia. That was a Virginia state election. And the Democrat General Assembly wanted the court to consider that election the intervening election required under Article 12, Section 1. The problem is, the last time the Democrats had full control in Virginia, they gave us a 45-day election that began on September 19th of 2025. So by the time the General Assembly passed the gerrymandering amendment for the first time, Virginia's election had been going on for 6 weeks, and over 1.3 million Virginians had already voted. Now, we have had over 60 constitutional amendments proposed since the 1971 rewrite of Virginia's Constitution. Never before, in over 60 different instances, has the Virginia General Assembly passed a proposed amendment while Virginians were voting. Never before. This was unprecedented. And the Democrats' position, carried by the Attorney General Jay Jones, was that the election, for purposes of that intervening election requirement, was just Election Day. And so the fact that Halloween was before Election Day, they argued was adequate to fulfill the requirement, the strict requirement of Virginia's Constitution. The majority today rejected that argument by a vote of 4-3. That 4-3 vote broke down on partisan lines. I'm sorry to say that the 4 justices who voted to reject the referendum as unconstitutional were all appointed by Republican General Assemblies, and the 3 in dissent were all appointed by Democrat General Assemblies. I'll come back to that point later, but this was a 4-3 decision rejecting the referendum. That means that Virginia's current 6-5 map remains in place and is the official map of Virginia for now and the foreseeable future, in the absence of some other attempt by the General Assembly to properly amend the Constitution. And to be specific about that constitutional amendment, the gerrymander amendment was intended to replace Virginia's 5-year-old bipartisan redistricting commission, which had passed by a 2-1 margin in just 2020. That was what they were attempting to undo. There is a second case that enjoined the certification of the referendum. That case is now moot and will never be decided by the Virginia Supreme Court because the referendum has been thrown out. There's no need to address the other constitutional and statutory violations by the Democrat General Assembly. Additionally, there's a third case addressing the gerrymandering maps themselves, and that, of course, is also now moot because the referendum was thrown out, so the General Assembly could not draw new maps. And so Virginia's congressional maps for 2026 remain the same as they were in 2024 and 2022. going through the opinion, that's the summary version. I'm looking at my notes here. I would note for the lawyers listening that there was absolutely no mention in the opinion of the statute that was alleged to have been violated. Virginia Code Section 30-13, which requires circuit court clerks to put a notice on the courthouse door 90 days before any election of then operative proposed state constitutional amendments, like the gerrymandering amendment. So under that statute, the clerks would have been required to post the language of the amendment on the courthouse door in June. Well, the fact that the Supreme Court ignored that and decided a constitutional issue based on the theory of constitutional avoidance, by which courts try not to reach constitutional issues if there's another way to decide the case, indicates that that statute will never be useful to a challenger in getting a referendum thrown out if it is violated and clerks of court don't post notice. So that is the statutory challenge that was part of this case. The other constitutional challenge that was part of this case was related to the General Assembly's use of the special session, and there were two problems with it. First, it was called in 2024, May of 2024, to deal with budget issues. So first is the agenda. It dealt with the budget and those things in the budget resolution, and the resolution said that the agenda could only be changed by unanimous consent. Well, they changed it by majority vote to add the constitutional amendment. So the agenda change in violation of their own resolution was issue one. Issue two, these are state constitutional issues, was the fact that that special session allegedly carried over through and past and out of the 2025 general session of the General Assembly. And the argument of the challengers was, the Republicans in this case, was that the general session of the General Assembly ends any special session because general sessions are unlimited, anything can be proposed. But the court, in footnote 6 in particular, said we are not going to reach that question because we have decided the referendum was unconstitutional under Article 12, Section 1, and so there's no need to reach the questions related to the General Assembly's special session. So to recap, there were three legal challenges: a statutory challenge that the clerks didn't post notice of the amendment prior to Virginia's 2025 election. That challenge was ignored by the court, literally wasn't even commented on by the majority, indicating that the court will not throw out a referendum based on that statute. The intervening election requirement of Virginia's Constitution was violated. That was the determination of the court that affirmed the finding below of the lower court and thus threw out the referendum. And then the third challenge, the constitutional challenge on the special session issues, was raised but explicitly not addressed because the case was resolved on the other constitutional basis. I would note that the majority opinion went to some length in laying out legal authority that would question whether that special session would have been viable, even in the absence of the court's ruling on the Article 12, Section 1 provision. Okay, that is the summary. Melody, if you want to allow